Now call the case of 125-500 in Ray Spencer.
May it please the court, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office. Madam Chief Justice, I would like to reserve 2 minutes.
Brandon, thank you.
Thank you. This is an original action in attorney discipline involving the respondent Mitchell J. Spencer. Mr. Spencer was admitted to the Kansas bar in September of 2017. In April of this year, the ODA filed a formal disciplinary complaint against Mr. Spencer. After Mr. Spencer filed a timely answer and the parties had further discussion regarding the contested issues, the parties decided to forego a disciplinary hearing and submit this matter to the court pursuant to a summary submission agreement pursuant to Supreme Court Rule 223. I want to briefly discuss the facts and rule violations that the parties stipulated to. During the evening of October 7th, 2019, Mr. Spencer was playing golf with his mother at a club in Wellington, Kansas around 7 p.m. After they were finished golfing. Mr. Spencer drove the golf cart he had rented from the club through the club's parking lot in order to return it. As Mr. Spencer was driving the cart through the parking lot, he was distracted because he was looking down at his cell phone. This caused Mr. Spencer to drive the golf cart into the back of a truck that was parked in the lot. The collision caused damage to both the golf cart and the rear bumper of the pickup truck. After dislodging the golf cart from the truck, Mr. Spencer proceeded to drive the golf cart to where the club stored golf carts. He then left the golf club with his mother, and mother was driving the car. At the time that he left the club, Mr. Spencer, he knew at that time that the collision had caused damage to both the truck and the golf cart. Despite knowing this, he didn't take any action at that time to notify anyone about the accident or leave his contact information so the golf club or the owner of the truck could contact him. Mr. Spencer didn't timely notify either the owner of the truck or the golf club regarding the accident the day after. 3 days after the accident, the owner of the truck saw Mr. Spencer at the club and approached him to discuss the matter. 9 days after the accident, after the golf club had already reported the matter to the Wellington Police Department, Mr. Spencer sent a Facebook message to the manager of the golf club asking about damage that had been done to the golf cart. On October 23rd, 2019, Wellington Police Chief Tracy Heath conducted a formal interview of Mr. Spencer regarding the accident. During that interview, Mr. Chief Heath asked him about whether he knew that there had been any damage caused to the accident. And during that interview, Mr. Spencer said that he was not aware of any damage that had been caused by the collision. That was a false statement. Ultimately, Mr. Spencer received a citation for violating KSA 8-1605, duty of driver upon damaging unattended vehicle or other property, which is classified as a Class C misdemeanor. The matter was originally filed in the Wellington Municipal Court by the city prosecutor, but the city prosecutor later dismissed the matter and referred it to the Attorney General's office for prosecution. Ultimately, in June of 2020, the AG's office instituted a traffic case against the respondent in Sumner County District Court. Prior to that case being filed in District Court, Mr. Spencer had paid for the damages his accident had caused to both the golf cart and to the pickup truck. In July of 2020, Attorney Michael Brown forwarded a copy of the Sumner County complaint to the ODA. The matter was docketed for investigation, and Mr. Spencer was asked to provide a written response. In his written response, Mr. Spencer failed to acknowledge the full extent of the damage the collision had caused to the golf cart and the truck, and gave the impression that he had timely notified both the truck owner and the golf club manager about his involvement in the collision. Ultimately, Mr. Spencer retained counsel and submitted a supplemental response to the complaint, acknowledging his failure to timely take actions to notify both the truck owner and the golf club about the collision.
Counsel, I'm gonna interrupt you there and just ask not really a legal question, I guess, but help me understand why this isn't all essentially a silly exercise over a busted taillight, which everyone who actually was involved basically resolved like using common sense and outside the confines of the Supreme Court courtroom.
I asked myself that same thing when we were prosecuting this case. And my only response is that initial accident happened. If Mr. Spencer would have just notified the club and the truck owner at that time, or even the day after, or even 2 days after, and made the offer to pay for the damages, this matter would not even be in front of us.
But
right now.
that ultimately happened. I guess this,
It
it
ultimately-
strikes me that this case could be a poster child for what often flies under the heading of complaints that we live in an over litigated society.
I think what elevated this to being in front of the disciplinary administrator's office was first we received a complaint, and then once
Sure.
we investigated it.
I'm not
Um,
criticizing your office. I'm just, boy, this just like seems like a snowball that should not have been,
Well, help me with that because I had the same initial reaction to this. I read the submission here, the joint as being elevating the incident because of what the office less than forthright responses to the initial investigation, ethics investigation complaint. Am I reading that wrong? In other words, we not only have this incident, which is say what you want about it, but then it's aggravated by what you saw as not being honest in responding to your inquiries. Is that right?
That would be correct. I mean, going back to the incident when I think what elevated this was the October 23rd, 2019 statements to the police chief denying that I didn't know at the time of the collision that any damage had been done. And then once the police chief showed him surveillance videos of the collision, I think it became quite evident to Mr. Spencer that that was not a really a great position to take. And so that, in addition to that, the fact that this occurred in Wellington, the county seat of Sumner County at the time, Mr. Spencer was an assistant county attorney there, was also a city attorney in another municipality located in Sumner County. I thought in my mind elevated this to resulting in a disciplinary complaint. Plus, I could tell you that the review committee considered prior to filing a formal complaint, Mr. Spencer, through his attorney, applied for diversion. The review committee reviewed that application, determined that because of the dishonest conduct that occurred in this case, that Mr. Spencer wasn't eligible for diversion under the diversion rule, which would be Rule 212B, saying that if a respondent engaged in dishonest conduct, they're not eligible for diversion. So those are the reasons why we resulted in a formal complaint. But again, because of, yes, it was a golf cart that ran into the back of the truck. That's why ultimately I think the parties agreed that I need to go to a disciplinary hearing on this, that this could be resolved through a summary submission agreement.
Well, let me follow up with one other thing. So the probation plan, the review of his practice and the agreement regulate the intake of clients and kind of bring down the pressure of his private practices the way I'm reading. Appears to me that that probation plan is the result of what was submitted from the psychologist respondents present state, if you will. And so therefore some additional supervisory thing, because, you know, I don't know, honestly, you look at this event and it doesn't cry out for practice supervision. So I'm just saying, the way I'm reading this again is it appears that as the parties work themselves out, it was a good idea to have additional supervision practice. Is that right?
That is correct. And I think, be honest, Mr. Spencer's attorney approached me, asked about a possibility of doing a public censure, of us agreeing to a public censure. I was in agreement with that because, again, at the time of this accident with him, Mr. Spencer being an assistant county attorney, also being a city prosecutor, I thought that this warranted something more than a public censure. But I believed that Mr. Spencer should be able to continue practicing law and not have to suffer the consequences of the suspension. That's why I was in agreement with probation. And so Mr. Rapp, Mr. Spencer's counsel, put forward the probation plan. I added a couple of additional conditions, primarily being the additional ethics CLE and the letters of apology to the 3 individuals. And they were in agreement with that. And that's why that's the probation plan that you have before you today.
Was it, I can't remember exactly, but was there at some point private communication or something that that the respondent felt like that it was an act of retaliation, act of retaliation by the complainant?
Yes, that could be found in Mr. Spencer's response to the complaint. Michael Brown, who is an attorney, I believe he practices in Derby. And this is outside of the record, but
But is there,
I think
is
Mr.
that response
There is
letter
his
in the
response
record?
saying that it was retaliation because Mr. Spencer had filed a disciplinary complaint against Mr. Brown. And so Mr. Spencer felt that this forwarding of this complaint from Sumner County to our office was in retaliation for that prior discipline filed against him. Yeah, that was, at least that's what Mr. Spencer put forward as Mr. Brown's motivation for forwarding that complaint to our office.
In the first couple of years that practice, he did file multiple ethics complaints against multiple.
Again, this would be only from Mr. Spencer's response, but I'm only familiar with the disciplinary complaint that he would have filed against Mr. Brown. And then the city prosecutor in Wellington, Sean DeJarnett, I believe Spencer may have filed a actual judicial complaint against him because Mr. DeJarnett, I believe, acts as a municipal judge in one of the municipalities around the Wichita area.
Let me go back, if I could, to the alleged dishonesty here. As I read the summary submission, there was a conversation between the respondent and the truck owner, at which point essentially it was trying to read between the lines here, it was, hey, sorry I hit your truck. Yeah, no worry, everything's fine. And then later, the alleged dishonesty comes from the interview with the police. I guess applying a technical definition of damage is where you get to dishonesty, but in the context of just regular human life, right? Human conversation. Oh, I talked to the owner. He said everything's fine. Cop asks me what's going on. No, there wasn't really any damage. Oh, well, we have this video surveillance of you. It just strikes me as being, I recognize the technical nature of the allegations here, but is this form over substance? The substance of this, I'm struggling with, obviously, for my question.
Right. I would also refer you to the damage that was done to the golf cart, which they provided an estimate to the police of being $700. So just the damage to the truck wasn't the only thing that was a result of the collision. There was damage done to the golf cart. There was damage done to the truck.
Is there any evidence in the record that would demonstrate that
I believe
he knew about damage to the golf cart?
Stipulated to knowing that there was damage done to both the truck and to the golf cart. So it's not just the damage to truck. I mean, it was a 1995 Silverado. The owner of the truck got an estimate saying that the piece of rear bumper that was broken off, if you wanted to just replace that, was $29 to buy that part, but it was also, I believe they got an estimate of $90 labor to literally take the old bumper off and put that on. And so the damage wasn't minimal is what I guess I would respond to. In conclusion, I would just ask this court to accept the recommendation that the parties have jointly come together with as imposing a 90-day suspension, stay that suspension, and place Mr. Spencer on probation for 1 year pursuant to the terms of the probation plan the parties have submitted to you. Unless there's any other further questions. I say I have no further time. I'll address you during rebuttal.
Thank you.
Thank you.
May it please the court. Chief Justice Lukert, members of the court, my name is John Rapp. I practice in Wichita, Kansas at Hinkle Law Firm. I'm here today representing Mitchell Spencer. Mr. Spencer does wish to address this court. If you all will listen to him, I'm sure there may be some questions the court may have and want to ask of him. Also present today, many of you know him, is Mitchell's supervising attorney, Alan Roop, a member of Lewis, Brisbois, Bisgard, and Smith. He works out of the Wichita and Kansas City offices for that firm and is proposed to be Mitchell's supervising attorney. Focus of today's hearing is the appropriate sanctions to be imposed against Mr. Spencer for the misconduct he has admitted. The parties, both the disciplinary administrator and the respondent, have submitted a summary submission agreement, as was discussed in Mr. Vogelsberg's address. Both parties are recommending a 90-day suspension, with that suspension being stayed and him being placed on 1 year of probation. It is often said that the primary purpose of the disciplinary process is to protect the public from unscrupulous lawyers. Mitchell Spencer is certainly not an unscrupulous lawyer. You heard the facts that gave rise to this case, and it was just a number of missteps after the incident at the golf course. Mr. Spencer is, in fact, a very gifted, hardworking, honest lawyer and a very good man. He is active in his local bar association community and well respected by his peers. You know that Mr. Spencer has fully cooperated with the disciplinary administrator's office since the advent of this matter. He stipulated to the underlying facts and to the resulting violations of the Kansas rules of professional conduct. He voluntarily entered into this summary submission agreement, admitting his misconduct. We understand that the picture painted by the formal complaint, the answer and stipulations, is not a pretty one, but it's not an accurate depiction of who Mr. Spencer is as a lawyer or as a person. Mr. Spencer was an extremely young lawyer at the time this event occurred, having graduated in 2017, this incident occurring in 2019. He understands the serious nature of his misconduct and that he is a lawyer all of the time.
Counsel, I'm going to just interrupt you.
Yes, sir.
And I completely understand where you're coming from, and you entered a summary stipulation or a summary submission that has stipulations. I understand all that, and I appreciate your recitation of, you're essentially stuck with describing the serious nature of this conduct. But I want to push back a little bit on that. Is this, I'm just reading paragraph 31 of the summary submission agreement, which is your client's response to the ethics complaint. And honestly, it just looks like that looks pretty good to me, that response. I'll just be straightforward. How did we get from, or from your perspective, I guess, do you think that the respondent's response, which is recited in paragraph 31, that just all wrong? And obviously it is, given the summary submission agreement, but
I wouldn't suggest that it's blatantly wrong, but I would suggest that it's tailored to tell a story. And I've been advised, and there's some other facts that maybe aren't in the summary submission agreement, but inclusive of Mr. Saffel not wanting any compensation for the damage to the truck, whether he said it was fine or not, seemed to be a bit controverted. But whether or not he said it was fine and didn't want any compensation, he certainly accepted it when we got to that point. I too had problems analyzing this case from standpoint of the golf cart, because I got to see the wreck. I mean, it's on a video, and golf cart hits the truck pretty hard. And so under Rule 8.4, I had problems with, was there a commission of an obstruction of justice with Chief Heath? Were there other crimes that weren't charged that would come to light in front of a hearing panel? And so I guess, that was major concerns that I had. I do not do anything unethical regarding the golf cart incident. I think in a broad sense, maybe that is true, but under 8.4, telling falsehoods or half truths, even out in a public sense, could be considered a violation of that rule.
Well, so that gets just to this is my bigger question about how our ethics rules ought to be applied. There might be facts that aren't in paragraph 31 that would color or change the way it appears to me, but just looking at that, and frankly, the whole summary submission, it just looks like the way this was initially handled is just the way mature, ordinary adults handle things that happen. And that now we've elevated it into, criminal charges and disciplinary cases, and just wondering if that's is that what we want from our ethics rules?
Certainly, as respondents counsel, we took every effort, starting with censure, informal admonishment, diversion. All of those were denied, and what I was advised was the Office of Disciplinary Administrator was holding him to a standard, and part of that was because he was the second in command in Sumner County as assistant county attorney. And he was held to a higher standard because of that, to be honest and forthright during this investigation.
What's wrong with that? I mean, he's a prosecutor, he's assistant county attorney. He understands the implications of falsehoods to law enforcement when you're being investigated. And that's what he did. I guess that, to me, and I agree with my colleagues who've spoken about this, you start reading this, it's like, what are we doing? But just that alone seems to me to trigger a pretty big concern here.
And that was a concern that we had as attorneys, what was going to happen before the hearing panel when that was discussed and those facts came out. What sort of recommendation was going to be made by them at that point?
And he did, it is true, right? I mean, the record shows that he falsely stated to the police chief that I wasn't aware that my accident caused any damage to the golf cart, but he really was aware, right?
Yes.
Thank you.
Tell me about the practice supervision plan. That, I mean, honestly, again, looking at these facts, I can see why we've got a disciplinary thing. I don't know that it cries out for practice supervision until you see that report from the doctor. And I understood Mr. Vogelberg to say that you suggested the supervision. But just tell me about the plan, regardless of whether I'm right or wrong about that.
Well, certainly at face value, it seems like there may be too much supervision or be unnecessary supervision. Mr. Spencer left the county attorney position shortly after, it was in the fall of 2020, and has been an attorney at Lewis Brisbois, where they have a number of mentors and a system. And Mr. Roop runs a tight ship over at that office, and Mr. Spencer works directly under him for the most part. And they oversee a lot of his work anyway. I think the practice plan is a good plan because in trying to understand how we got here, Mr. Spencer underwent a psychological evaluation with Dr. Lance Parker and Dr. Parker opined that anxiety and stress caused Mitch holds himself to an extremely high regard and holds himself to a high, he expects a lot of himself. And when he fails, he has a hard time admitting that he failed. Or when he does something wrong, he has a hard time admitting he did something wrong. The idea of having a practice plan with a supervisor may take some of that pressure off of Mr. Spencer to feel like he can't admit when he's wrong. He can go to his supervisor, in this case, Mr. Rupert, one of the other 1,500 attorneys in his new firm, and express to them that I'm having trouble with this issue. How should I handle this? Hey, I had an accident with a golf cart, hit a truck. What should I do with that? You know, somebody else being there to talk to Mr. Spencer about anything, even outside of his practice, would be helpful. We all need mentors or needed mentors at one time in our life. I've been blessed with many and would not hesitate to call them if I was in a situation to say, hey, let's get another set of eyes to look at this scenario and figure out how I should have handled it better or different, or just have some advice. That was the reason for the probation plan, was to maybe take some of the stress off Mr. Spencer that he feels to try to be perfect. And that brings up an interesting point, because Mr. Spencer is, while he's being held to a higher regard, higher level of duty because of his fact he was in the county attorney's office, he left there over 2 years ago.
How does that work? Do we have two sets of rules? One for prosecutors, and I mean, we have a specific ethics rule that covers prosecutors in the execution of their official duties. But beyond that, how does this work where we create a higher standard based on what job you have?
Well, I would submit, and I can't cite case law at this time, sir, but it seems to me that we've read over the years that prosecutors in dealing with law enforcement and whatnot, their duty to be honest and forthcoming may be higher than a
Well,
normal citizen.
there is a specific rule
Yes, sir.
that governs prosecutors, but that rule is not implicated in this case. Is it?
I don't have a good answer for that, sir. Mr. Spencer's in a completely different place in his life. A lot of changes have happened in the last 2 years. He works at a different firm with a number of mentors. He got into a bit of a toxic relationship with some of the other lawyers in the Wellington, Sumner County area. I can tell you, I know that from witnessing it. I practiced down there at those times, and the defense bar and the prosecution teams were not getting along very well. And you've heard some of that today with ethics complaints being filed by folks against both sides going at each other. He's out of that. He lives in Wichita now. He's working at Lewis Brisbois, totally different area of law, number of mentors. I've stated that. I would submit that Mitchell is certainly a lawyer with a bright future and one that needs to put this mistake behind him. He's an asset to the community. He's an asset to his clients. He's an asset to his firm, and I'm proud to have him as a colleague. Respondent requests that he be suspended for a period of 90 days with that suspension stayed and be placed on probation for 1 year. Board have any other questions of me? Mr. Spencer would like to address the court.
Thank you. I apologize for being here today. I take full responsibility for my actions. And does anybody have any questions for me? All right, thank you.
Against my better judgment, I guess I'll try to address some of Justice Deagle's concerns. Where the heightened standard, the higher standard that we treat prosecutors at, I believe comes from this court's case law. I would cite In re Holste, 302 can 880 2015 long string cite in that opinion where the court acknowledges that they hold prosecutors to a higher standard. And so, not explicitly stated in our rules of professional conduct, but
Well, isn't there a notice? I mean, aren't there significant problems? I'll take you at your word that that's what our case law says. Isn't there a problem with that?
I think that
At a minimum,
we-
like a notice problem. Shouldn't we have a rule that says that?
guess that would be up to this court to decide whether there should be a rule, but I mean, we've had a long line of cases talking about because of the immense power the prosecutors hold.
Well,
that's why
typically
we-
double standards in the law are frowned upon. And how is this anything other than a double standard?
I'd say if another attorney under these facts, if Mr. Spencer was not a prosecutor at the time, and if we had the evidence, including the conversation they had with the police chief, where he subsequently later admits that he knew at the time of the collision that the collision had caused damage, and he admits that when he told police chief that he was not aware of that was a falsehood, that would be an 8.4C violation.
And they would be,
We've had attorneys, non-prosecutor attorneys though, that have gotten, tagged with misleading law enforcement officers in the course of an investigation into other conduct. I mean, that gets brought up. I can't specify the cases, but I can recall them in several, traffic accidents and DUIs and that sort of thing, and, sort of misleading responses. And we talk about it being officers of the court, all attorneys. So this part doesn't strike me as getting you because you're a prosecutor. I mean, aggravating to have that, but we're all officers of the court. And we're not supposed to lie or mislead law enforcement.
I agree with that. In fact, one case, for example, would be Enray Mintz, 298 can
How do you spell
897.
that one?
It'd be MINTZ. Citations 298 can 897. That conduct, that result was an 8.4C, 8.4D violations. The conduct in that case was more serious than what Mr. Spencer was in agreement
Way
with. I
worse.
mean, that was that the lawyer in that case was trying to cover up his involvement with going out the night before with his girlfriend who was a recovering alcoholic. And so obviously much more serious, but that's an example of a lawyer, non-prosecutor, misleading police, being held to a violation 8.4C.
I just want to clarify that in this case, it seems very clear to me that everyone has conceded that the disciplinary administrator applied a higher standard to this respondent. And you just began your argument by saying that 5 minutes ago.
I would say the recommended sanction that I was recommending that I told Mr. Rapp that I would agree to would be probation. And that was on the basis of Spencer being a prosecutor at the time.
Okay, thank
But
you.
as far as the rule violations
Right.
go, that didn't play a part. Him being a prosecutor at the time didn't make me determine like, oh, this was an 8.4C violation.
thank
So I'm sorry if I
No, you've been clear. I just wanted to clarify as further. Thank you.
And then I guess, well, I'll address you cited paragraph 31 of being the summary submission agreement, thinking that was an appropriate response. I guess I would politely push back with saying that when he claimed that it only cost $20 to fix the truck, when he made that response, he had already paid the estimate that the owner of the truck had received, which was $100. And so wasn't quite accurate. But also in that response failed to acknowledge that he also paid a $700 estimate for the damage done to the golf cart. And so.
Well,
that's
I thought he said he'd already made it right, basically.
at the time, so that statement comes from his response, which he provided to the ODA August of 2020. By May of 2020, he had paid both the estimate to the truck owner for the damages done to the truck and to the golf cart. But what I'm saying is in his response, did not even acknowledge any of the damage that had been done to the golf cart.
Okay,
No one was at the golf course. Was at the golf course who
I don't know. He stipulated that he was not aware of anyone being at the golf course as an explanation of why he didn't go out at that time and search out anyone at the golf course to report the accident to.
And in fact, the only person at the course was off in a outbuilding somewhere, not in the clubhouse, for example.
I
Correct.
believe he was at the golf cart shed where Mr. Spencer was returning the golf cart to, or at least that general area where the club kept the carts.
Does the fact that the respondent reached out to the manager of the golf course and asked, did you have any damage to the golf cart the other day? And never got a response, does that affect the later interview with the law enforcement officer?
I don't know.
I mean, why wouldn't it be reasonable for, let's just say a person, not a lawyer, just who had had this incident, be like, I reached out, I didn't hear back.
Yeah,
So I don't think there's any damage when the cop calls you.
say that we've submitted stipulated facts and Mr. Spencer has stipulated to, when
Right.
he told the chief, I wasn't aware that any damage had occurred, that was not true. I don't.
Thank you.
Thank you.
Thank you to all of you for your arguments today.